Alright, so now we're gonna go into for the remainder of this recording, it's just gonna be straight up the Community Legal Education Ontario Tenant Law Series. So this is about fighting an eviction. Alright. This is a more expansive document than what I was reading before. This is 22 pages. So let's read for the remainder of the recording. Fighting an eviction. It's against the law for your landlord to force you out without an order from the landlord and tenant board. Similar to what we just read earlier. So this is applied to you. This booklet is about the tenant's rights under the Residential Tenancies Act, the RTA. RTA applies to most rental housing in Ontario, such as rooms, apartments, houses, mobile home parks, and retirement homes. Some rental housing is not covered by the RTA. For example, you might not be covered if you live in a place that's supposed to be used for business, as we said before. Alright. So, if your landlord gives you notice, your landlord wants to evict you, usually the first step is to give a written notice. They can do this a number of ways. Putting it in your mailbox or hand it to you. Usually the notice will have a name that starts with notice to end your tenancy. It may have one of these numbers at the top: N4, N5, N6, N7, N8, N12, or N13. It tells you the date your landlord wants you to move. Your landlord must give you the notice a certain number of days before that date. The number of days depends on which reason for eviction your landlord has put on the notice. There are some examples in the chart. So you owe rent, that's 14 days, 7 days if you pay your rent by the week or day by the day. Or by the week or by the day. You often paid your rent late, 60 days. Alright. 28 days if you pay your rent by the week or by the day. You broke the law or ran an illegal business, caused damage, being careless, or disturbed the tenants. 14 days if it's the second notice within 6 months. 20 days the first time. You seriously risk the safety of others in the building or selling an illegal drug. 10 days. Alright. Your landlord wants to tear down the building or use it for something else. 120 days, all right? So your landlord wants to tear down the building or use it for something else. 120 days. In some cases, the notice must also tell you what you can do to cancel it. For example, if the notice says you owe rent, it must tell you exactly how much and when you must pay it to cancel the notice. Even if you're not able to cancel the notice, that does not mean you have to move out, but it means your landlord might take the next step and apply it to the board. If they apply to the board, your landlord does this by giving an application form to the board and paying a fee. The board mails you a copy with a notice of hearing. If you get these papers, that doesn't mean you gotta leave. You can be evicted only if the board makes an eviction order after a holding hearing, similar to what I read in the last recording. So stop the application by paying what your landlord says you owe. This isn't specific to this redevelopment plan, but we're going to read this anyway. Stop the application by paying what your landlord says you owe. If your landlord has applied to evict you because you owe rent, you can stop the eviction if you pay what your landlord says you owe before the hearing. It's a $190 fee your landlord paid to the board, and charges for any bounced or NSF checks. Get help paying rent. If you can usually pay your rent but are having a problem right now, you may be able to get help from organizations in your community. Some communities have rent banks that lend people money to help pay their rent. Rent banks don't charge any fees or interest for these loans. If you owe a small amount of rent, you might be able to get help from other programs that try to help people keep their homes. Homeless prevention programs. So check 211.ontario.ca. Make an argument with your landlord. Try to make an agreement with your landlord to stop, delay the eviction if you can't pay what you owe, you don't agree with the amount, or the application is not about owing rent. So you can come to a settlement. There's mediators who can help you try and reach an agreement with your landlord. You don't have to go to the mediation. You and your landlord can try to work out an agreement with a mediator's help or without. But bring a lawyer with you. Be very careful about signing an agreement, especially in mediation. If you sign a mediated agreement but then don't follow it, your landlord might be able to apply for an eviction order without giving you any notice and without you having a hearing. Before you sign any settlement agreement, try to get legal advice and make sure the agreement says exactly what you agreed to and doesn't include anything you think is not fair or that you will not be able to do. So prepare for the hearing. If you can't stop the application from going ahead, then you will have to prepare for the hearing. You might need to arrange for witnesses to come to the hearing, or you might need to make copies of papers or photographs you want to use at the hearing. Just trying to go through here. Let's see. All right. If there's a hearing, a board member will listen to why your landlord wants to evict you and why you think you shouldn't be evicted. It's up to your landlord to prove to the board that there's legal reason to evict you. You can call the witnesses. You can speak for yourself. If the board members agree that there's a legal reason to evict you, they can still decide not to evict you. They must look at all the facts. For example, how being evicted would affect you or your family. The board member must also look at whether your landlord has been following the law and of the rental agreement. In some situations, the board must let you stay even if there's a legal reason to evict you. So if your landlord failed to follow the law or rental agreement, is trying to evict you because you did something to protect your legal rights or because you got kids. So at your hearing, make sure to tell the board member everything that you want the member to think about when deciding whether to evict you. You might want to make notes and take them to the hearing so you can remember everything you want to say. Here's a key point. To help you prove what you are saying, it's very important to bring evidence to your hearing, such as witnesses, photos, audio or video recordings, inspectors' reports, work orders, letters, or receipts. So if there was a hearing, the board may have made the eviction order because a board member at the hearing agreed with your landlord or because you missed the hearing. All right? We read that before. So enforcing an eviction order. If the eviction order is not stopped, the sheriff is the official who is in charge of enforcing or carrying out the order. If you haven't moved out by the date the eviction order says, you gotta move. So the sheriff can make you leave and can let your landlord change the locks. Your belongings. If you're evicted by the sheriff, you got 72 hours to take your belongings. You gotta get them between 8 and 8 p.m. 8 a.m. and 8 p.m. Take all your stuff when you go. And then legal aid can help. Community legal clinics, toll free, 1-800-668-8258 or legalaid.on.ca. So it's that was a bit more expansive. There's also tenant duty counsel at many landlord and tenant board locations. They're paid for by Legal Ontario. They're lawyers and community legal workers who can give basic advice, help work out settlements with landlords, and review and help fill out some forms and documents, especially ones related to eviction. So that was kind of like the expanded version of that last info sheet. I don't know if there was more detail there that was useful, but again, that's for evictions. What you can do if any of this stuff starts to jump off. All right, peace.